Hi, it's Jeff Cohen from the Florida Healthcare Law Firm, and I'm here with Carlos Arce and Rachel Broughton. We're going to be talking about licensure stuff, ACA licenses, healthcare clinic licenses. We're going to go into the IV hydration space as well. But we find that there's a whole bunch of confusion and a lot of talk about what needs a license, what doesn't need a license, so hopefully you'll be able to extract some of that from here. We were talking earlier, the thing that inspired you to want to get to the table and talk with Rachel and I about this was what? What inspired that?
So a lot of what inspires us is there's a lot of client inquiry. So we represent clients that are from the most regulated hospitals, ASCs, meaning ambulatory surgical centers, healthcare clinics, to all the way down to cash providers that don't need a healthcare clinic license or a license, typically. But sometimes they get triggered where they do need a license, and that is what has led us to this conversation, because this conversation comes up a lot. And I thought it would be great to have Rachel on here, because HHA and nurse registry is her space, my space is more healthcare clinic. Although we work hand in hand and we understand both of them, we thought it would be great to instruct our clients and the public on these kind of questions that come up often in our calls.
So you mentioned HHA, you mentioned nurse registry. We know that issue gets batted around, those words, a lot in the IV hydration space, especially mobile IV hydration providers. Can you explain why? Why does the issue come up, and how do you instruct people about which road to go down?
Yeah, of course. So as Carlos mentioned, a lot of times these IV hydration clinics, when they're cash pay only and they're providing services simply in a fixed site, in a fixed location, that's one thing. But when you take it outside of that fixed location and you're going to these patients' homes, that's where you trigger the home health agency or nurse registry license. The difference between the two is pretty much whether you have a nurse registry, which is going to contract third-party independent contractors to provide the service, while a home health agency is going to have direct employees who are providing the service.
Okay, so if I'm a mobile IV hydration provider and I want to explore the idea of licensure, do I need to be licensed? They're ultimately going to hear from you or you that you're going to be looking at either nurse registry as an option or home health agency as an option. One is if you have independent contractors, and the other is if you have W-2 employees. Does that capture it? Cool. So when you have the conversation with somebody like me, mobile IV hydration provider, do you get any pushback from people saying, well, I have heard that there's no license required and nobody else is doing it that way? Have you heard that?
Absolutely.
How do you respond to that?
So typically, we get a lot of that for anything that we do, because I think that a bad trend, I think in Florida, South Florida primarily, is people tend to do things on trends and they do what everybody else is doing. And it comes to a shock when they meet us and we have to basically explain to them how the law works. And we give them the laws, the options, the risks, and the landscape of those laws. They are often, troubled by it. And that's when we get into these kind of conversations about licensure, and this is like a hot one for us.
Yeah. Well, I think largely because IV hydration is exploded. Am I right? Are you finding that in your practice too?
Yes, absolutely. And again, similarly to what Carlos said, time and time again, I hear clients say, well, we're just cash pay. It's just cash pay. I was told I don't need a license, but the whole providing services to patients in their homes or outside of some fixed location triggers this issue.
So that's an interesting statement that people make, because I've heard that too. Mm-hmm. And they're like, well, because it's cash-based, I don't need a license. And I think what they're confusing is the idea of an ACA license or a healthcare clinic license. Is that maybe what they're confusing?
They are confusing. So there's something called the healthcare clinic establishment permit, and there's a healthcare clinic license. And everybody that provides services as a healthcare provider needs a healthcare clinic establishment permit, especially if you're going to be ordering any types of pharmaceuticals or drugs that you use in your medical supplies, basically. So big third parties now that sell you medical supplies require that license. They require to have a physician that has a DEA active license that's on board with your facility. So that may trigger that. So clients will often confuse that and say, well, which one is it that I need, or do I need anything at all? And that's where I've seen confusion with those words.
Healthcare clinic establishment license isn't the same thing as a healthcare clinic.
That's correct.
And the mere fact that I, as a provider, let's say I'm a freestanding IV hydration provider or med spa or whatever it is, the mere fact that I'm standing there and I'm only taking cash, I'm not submitting claims for reimbursement, that removes me from the whole healthcare clinic license question. But we're still back with the question of, well, maybe especially if you're providing those on a mobile basis, maybe you need some other kind of license, like a nurse registry or a home health agency license.
That's right.
Yeah. So I mean, when you talk about, you start to layer on these licenses: home health agency license, nurse registry, healthcare clinic establishment, healthcare clinic license, ACA license. It's a really confusing space, isn't it?
Right.
Yeah.
It is.
And so I guess it's not shocking that people have a ton of questions, and we get pushback. You know what? One of the other things, as well, is this issue of medical directorship. Have you heard that confusion too? The people say, I need a medical director, and they don't understand the difference between a medical director and a supervising physician. Can you address that?
This is funny because Rachel and I deal with this issue maybe every single day. Because it comes up often where people that are interested in applying for a healthcare clinic license will say, well, I have my medical director and then that's all I need. And then we're like, wait, hold on. So a medical director has a certain role. Their role is essentially to govern the billing and basically coding and billing practices of a healthcare clinic, or in the situation of an HHA. They're essentially...
Of an ACA license clinic.
Right. Anything that's ACA, there's always a requirement for medical director because that's what they're doing. Their job is to make sure no fraudulent activities going on with the billing and submission for that part. Supervising physician...
Totally different.
Totally different. That's a provider who supervises basically a mid-level provider that's operating inside of a facility or basically out in the public. That's a Department of Health issue. That's not a ACA issue.
So if we're in the med spa space or the IV hydration space, and we have RNs, PAs, and NPs doing the bulk of the clinical services, that's where we really have this issue of supervising physician that comes into play. Am I right?
That is correct.
So how do you help people navigate that? How do you help them differentiate between, there's a healthcare clinic medical director, and then there's a supervising physician, not the same thing, which attaches to somebody that isn't an MD or a DO. How do you help them navigate that?
Well, I think it's a little bit different in the healthcare clinic space as opposed to the home health agency space, just because that role in a home health agency is someone known as the administrator. The administrator for a home health agency can be a physician, a physician's assistant, or a registered nurse. So they kind of take over more of that role when you're in the home health agency space, but I know it's very different for a healthcare clinic licensure. So that's something that it's important for us to get to the bottom of right away, kind of how the operations are going to flow, who is going to be doing what, and making sure that these professionals are performing services that are within the scope of their licenses.
Can we talk for a minute about this issue of what is a proper or properly qualified supervising physician? Because people get really confused about, well, is there 25-mile and board certified, board eligible dermatologists? They get very confused about all that stuff, and I wondered if you could kind of break that down a little bit.
Yeah, I mean, supervising physicians will vary basically on statute. So it just depends on the license that they're supervising and the type of service. So what we need to do is when a client comes into us and they say, we want to use a mid-level provider to render a certain type of service, we essentially take that kind of service, we look it up in the statute, and we figure out essentially, does it require a direct supervision requirement, a general supervision requirement, or some sort of remote supervision, meaning somebody that's just basically a phone call away. They will all vary depending on the specialty of the license and then depending on the service. So that's a real broad question because we have to basically get in there. We have to ask you a lot of questions about what you intend on doing, and you have to be very specific because if you miss something or you leave it out, you could trigger an unlicensure issue, meaning someone's performing services outside of their scope. And who are basically the people you got to be worried about? Well, you've got the Department of Health, right? You've got them. And then you ultimately have a potential for a malpractice lawsuit because How we've seen it is when somebody's not properly supervised and then they're rendering a service and that service somehow injures a patient, and when that investigation all comes about, guess what they're going to ask? Well, who is the supervisor? Well, I didn't know I needed a supervisor. Okay, well, what was the how was the relationship documented? Well, we didn't have one, meaning supervision or protocols.
Right.
And that's where I've seen malpractice suits that end up basically, now it's not just a malpractice lawsuit, it's an unlicensed issue, and now the Department of Health is involved in the actual civil litigation. So it's a tricky one, and it's something that if you're going to be opening a practice or you're operating a practice, maybe call us and just help. We can help you with that issue and to understand if you're in compliance.
That's a great way to describe it, because I think a lot of people want a question and then the simple answer, and the difficulty with that is you guys have to look at the landscape within which that arises, because you're talking about IV hydration clinics, for example. It's a totally different legal analysis than med spas. So we all know, probably most of the folks that are watching too, no, RNs cannot administer Botox. They can't administer Botox. And they certainly can't do it independently without getting into all the nuances. But to your point, you've got scope of practice that attaches to each license, and then you have this other thing called supervision requirement that applies to each person depending on their license and what they're doing. Yeah, so it's a little bit, it can sound like we're making something simple complicated. The truth is it is complicated, and our job is to take a complicated landscape that people present us and simplify it so they can understand it and use it in a compliant way.
Right. And that's a lot of, like, for Rachel and I, like, when we address home health agency issues or licensure concerns or healthcare clinic, and we can help clients prepare the forms. So what we find is that clients come to us and they're worried, and they say, I'm midway through the application and I just don't know if I got it all right. Well, let me tell you something. That is the premium point, because if you didn't get it, if you're feeling like you're not getting it right, it's probably because you're not getting it right. ACA is very sensitive as to how an application works. If it's not properly documented or not properly filed, you are not going to get a license. No matter how many times you try, you're just going to keep wasting that admin fee. For Rachel and I, this is an everyday thing. We do these licenses every day. We can do them in our sleep at this point, because we understand exactly what it takes and what ACA wants to see because of our experience. So Rachel, you want to talk a little bit about, like, the nuances and, like, what are the things that you're looking for, and how do you make it successful?
So something that I like to do when I have a new client who is interested in obtaining any sort of ACA licensure, I like to gather all of the information and documentation that we're going to need in advance. A lot of times I get clients who say, well, we had this piece of it done, and then we brought in this piece, and we wanted to finish with this section. I think it's best at the very beginning to compile all of the information and documentation that you need before starting the application process. So that's definitely number one. Number two is having an attorney or someone whose sole attention can be devoted to the application and its process. I've seen a lot of times clients will try to do it themselves, and in addition to providing patient care and things of that nature, and things can get lost in translation. So I think having someone whose sole responsibility is to handle the application process is also very important.
Let me take it to one step level to what Rachel said. I had a client once who came to me and said, a lawyer helped me prepare the ACA application, and he thought that I was exempt. And ACA ended up flagging this person and saying that they were unlicensed and that they were operating without unlicensure, and now that was triggering essentially a third-degree felony. And because we do that too, we do responses when ACA triggers you for unlicensure and all that. We can handle that as well. And I said, give me exactly the emails. Let me see exactly how the lawyer went through it. And it was a lawyer that said he's a health lawyer, he's a corporate lawyer, and they were basically engaging in things that they didn't understand. They were thinking, oh, well, if I just trick this box, then ACA is going to approve it. Well, ACA's job is not really to check you. Their job is, if you get the application right, you get the license. But they have a little caveat that says it's your responsibility not to misrepresent any of this information. And that's why they were getting in trouble. And I say this story because that RN, that unfortunately that happened to her, she was distraught. She was dealing with criminal liability, civil liability, now legal fees. She's like, what do I do? How do I fix this? Now she's got a billing issue because she's been billing now federal payors and commercial payors, and she wasn't licensed, so now you got to undo that. It's a can of worms that you cannot unwind, and you can go through it, but it's going to be costly and potentially cost you. I mean,
and that's why I want to, if we could, tell some war stories of licensure gone wrong. The first, and I really want to get some of that out because people need to understand how bad it can look and how bad it can be. The first time that I saw something like that, it was a $20 million transaction. The buyer we were representing the seller. The buyer was represented by a firm from, I believe, New York, or could have been Washington. Anyway, they closed the transaction and they don't do a change of ownership, no chow. So they ended up buying an operating business which was cash flowing and having to shut it down until they got the license. Yeah. And that was really shocking and very upsetting because you had an operating business and these guys had put $20 million into the transaction to get it done so that they could buy it, and a large part of the business enterprise couldn't operate. It was shocking. It was very surprising to everybody around the table that that issue wasn't identified by the buyer and wasn't handled. We had raised it earlier and it just didn't get followed up on by buyer's counsel. Can you tell a story or two just so people can understand what it looks like and the problems that they'll have if licensure isn't properly handled?
yeah.
I could tell a dozen, but I won't. But the one that comes to mind is very similar to what you were just discussing. It starts I've seen it start in the acquisition process. You have a buyer, they find a company that they want, and they want it so bad that they don't exercise proper due diligence. And when purchasing a company, yes, there's the financial due diligence and all of those aspects, but a lot of times buyers, don't prioritize licensure due diligence. Is this the appropriate license? Do we have it? Does this trigger what we refer to as a chow? Things of that nature oftentimes are overlooked in the purchasing process. So I think that's something that I've seen happen time and time again, anywhere from, well, the seller told me we didn't need the license, all the way to, I didn't know we needed a license. I didn't know the seller had a license. I've seen it all. So yeah, it certainly happens all of the time.
Yeah, I've had the same issue on transactions because, a lot of what we do here, I always like to say we're like 30-40% full M&A firm because we do a lot of transactions, specifically in the healthcare space, and almost always there's a licensure concern or a licensure issue. Unless you're dealing like provider to provider, and even then, there's always the tricky nuances of those little very weird rules where it may trigger a healthcare clinic. But for the most part, if we're talking, private equity, if we're talking about basically non-provider buyers, there is a licensure concern because you need to have one to operate in Florida. We like to say that about 30 of the states there's a corporate practice of medicine restriction, which means you can't operate a healthcare clinic, meaning a medical practice. No matter what, you'd have to, work through some sort of management company where you're only allowed to manage and not allowed to own. And that's a big misconfusion of MSOs. People like to say that all the time. Oh, I'm going to own it, but you don't own it. The physician owns it. Florida actually is one of those states that allows non-physician owners, and I think for like private equity, it's appealing, right? Because there's that control aspect. So what happens in that scenario? I've seen private equity deals basically go south where they've invested now family practice money, they've invested money that's been invested into a healthcare transaction, and then they figure out, well, there's a licensure concern. We've got to stall all operations. So, usually private equity, when they're investing, they have projection sheets, and they're showing that to their investors. They're saying, well, this is why we're going to buy this entity, because look at how the projections are going to show. If we inject this kind of money, capital, the company's going to go to this next level. Well, if you interrupt it because there's a licensure issue, and now we're talking about potentially answering an administrative complaint, then having to get the licensure, maybe potentially not even able to get the license, you may then have to sell it to the next person, and you've now wasted lots of money, you've created a liability for yourself and exposure.
And it's a really tricky issue, this whole ACA clinic issue. A lot of people will oversimplify it, and I'll never forget one of the bigger messes that I got involved with was a acquisition in the imaging space, and we were acquiring on behalf of the buyer a number of new imaging centers. So we were buying, and he had already had a platform, the buyer. Well, when we went down and we started stripping down the ownership chain, we found lay people in it that didn't fall within the exemption. So a lot of folks that will watch this know that when a physician owns a healthcare business, that's exempt. They don't have to go through any process. They're exempt from the requirement. And if they and their spouse own it, they're exempt. So a lot of times when physicians or clinicians are going through their business build and they're importing this person and that person into the ownership chain, when they go outside their immediate family, they don't realize that they're running the risk of implicating the need for licensure, and they didn't need it before. But if you add this person to the licensure, to the business as an owner, all of a sudden you have the need for licensure. And of course, they're not aware of it, and they're not aware that there are alternatives in terms of profit share and revenue share without making somebody an owner. But I'll never forget when we were going through, we were going to add on these new, which would have enhanced that business platform by about 40% revenue. And they find out that the entire thing never got licensed 2 years prior. And that was a huge wake-up call and a big mess to clean up. So I know that you've seen it because we were talking about it in a dental transaction not long ago, and it's unfortunate when they get there. But to your point about regulatory due diligence, I wish buyers would do more regulatory due diligence at the same time that they're doing financial due diligence. Yeah, because that would make things happen more smoothly. That would make that transaction go more quickly, and it would be a lot less upsetting than it is when they come up with a surprise like that.
Absolutely. I agree.
Talking about due diligence for a second, there's a couple cases that came out of DC. Department of Justice released 2021, 2022 cases where private equity is being held liable now for not doing extensive due diligence. A lot of private equity firms only want to focus on financial due diligence. They don't want to do the regulatory due diligence, where there's been indications and found where there maybe have been some sort of anti-kickback violations going on, False Claims Act issues, and private equities have bought these kind of companies thinking, well, look, the rev share looks great. It makes sense for our portfolio. Down the road, Department of Justice will investigate and say, well, did you do that kind of due diligence? And they'll say, no, we didn't. We didn't think it was in our scope. Well, they've now released basically guidance and said, yeah, it's your job to go thorough and to basically investigate all of it, and you can be held liable. And if you just turn the blind eye and say, I don't want to hear about all the mechanics of it, you can also be liable. And we were studying a couple of those kind of cases that were coming out of the Department of Justice recently released.
I wanted to talk, because you raised a good point, this issue of that a lot of buyers are not aware of in the healthcare space. The difference, and it's so fundamental that we skip over it a lot, the difference between buying the assets of a business versus buying the equity, the shares, or the membership interests of a healthcare business. In the healthcare space, a lot of buyers don't understand this, but there's no way to escape liability for both disclosed and undisclosed liabilities in a healthcare business if you buy the ownership interests or the shares. If you're a buyer of a healthcare business and you buy the stock or the ownership interests of an LLC, you get the liabilities both disclosed and undisclosed, no matter what. CMS, Medicare, will not go back into a transaction where there was a sale of a Medicare reimbursed entity and say, oh, this happened before you were an owner? Oh, well, we'll go after the prior owner. They don't do it. They're coming after you as a buyer because CMS is very clear. Whoever owns, whenever they own, they're liable 100%. And I think that's really shocking to a lot of buyers of healthcare entities. A lot of them will say, well, I wasn't an owner then, so I'm not liable. It doesn't work that way in healthcare business at all. And if you think that you can go back into the transaction document and travel under the indemnification section and try and get money back from somebody that you paid money to, think again. It's very, very difficult to do in Florida.
Yeah, it's funny that you're bringing that up because Rachel and I were dealing with that, a change of ownership under a Medicare number. You want to talk about that? Because we were navigating that issue.
So yes, the issue can be very complex because basically what the Medicare rule is, the Medicaid rule is the exact opposite. So with these sort of transactions, you really, a lot of times when you're purchasing a healthcare entity, you're purchasing the contracts that that entity has, including Medicare, Medicaid, any commercial, any contract whatsoever. So it's very important to vet those on the front end as to what will happen once ownership is transferred.
Could we talk about this issue? It's not about governmental payers, it's about commercial payers. Why is the issue of commercial payer agreements so complicated and so upsetting to buyers of healthcare entities? Can you explain? I know you've been through it a ton.
Yeah, so the biggest issue is relating to the assignment provisions or if the contracts are even assignable and how they were titled. So whenever I do due diligence and I'm reviewing to make sure that a contract can be titled, I always look at the first thing is, was the contract titled to the provider, sole name, and basically individual MPI, or was it titled to a group practice and a group practice MPI? That's going to make a hell of a difference. And let me explain to you why. If you leave it to the doctor or for the physician, there may be a way that the insurance carrier will not allow that contract to now graduate into a group practice. Because the trend is the portals are closed. So you can't get contracts nowadays. So the only way to get a contract essentially is to buy one through either an asset deal or to buy one through an equity deal. So unless it's titled to a group practice, it's a very hard shot. Okay, let's say you got to that point, that sounds all good. Then you get to the contract and you're looking, well, can I assign the contract? Well, there's going to be a triggering provision where you have to alert the payor with a certain amount of time and you have to wait for consent. You just can't automatically start billing on it. The problem is a lot of people don't do that triggering event. They think, oh, I just bought the entity, I did a full sweep of equity, I don't need to disclose that there was a change of ownership. Where that ultimately can become a false claims allegation because now what you're saying is you're misrepresenting to a commercial payor, you're committing insurance fraud. Why? Because there was a change of ownership. There's a new person in the role, there's a new person who's the owner who's taking the funds. That person has not been vetted or credentialed with the plan, and now the plan can come after you and say, that's a false claims, we're going to claw back the money. Oh, and by the way, we're going to alert the Department of Justice that you've been engaging in nefarious activity.
So all of this really suggests to buyers, you really have to take a look at the issue of managed care agreements if that's a lot of the revenue stream that you want to continue. Don't assume ever that any of those managed care contracts will come with you when you buy the entity.
That's right.
Yeah, that's the big thing. So you're looking at the assignment provisions and you're looking about what happens on the back end of that because people will continue to do business under those payer agreements. And like you say, they get clawbacks and they get sometimes criminal probes or SIU probes, Special Investigative Unit probes. And well, that explains a lot. And it also explains a lot why a lot of people, when we get into the kind of due diligence phase with a buyer and we're taking them through not just kickback analysis or licensure analysis, but we're also saying, what's your expectation of the transaction? When you successfully complete the transaction, what have you got? And so it's important for us to understand what they're expecting to get when they buy, because there may be a disconnect between their expectation and the actual landscape of buying a healthcare business in Florida.
Right.
Yeah.
Absolutely.
I have a war story I wanted to tell because this one is one that was troubling me it still troubles me now to think how wild this is. I had a provider, the nurse registry. A lot of the healthcare payors right now and government payors are using third-party administrators, TPAs. And these TPAs, what they have is they have a credentialing procedure books that say in order to be credentialed with a certain plan, you have to meet box A, box B, C, D, E, F, G. So if you don't have certain disclosures that you've made or you've misrepresented them, that ultimately triggers you cannot reimburse. The issue here was that the nurse registry essentially was operating in many counties, and not in all the counties did they have a nurse registry. They had companionship licenses. They had skilled, minor home services, but didn't include like the skilled nursing part. Mm-hmm. And the TPA was flagging them because they were saying, well, you weren't licensed from this period to this period. The TPA went into the registry of the licensure and found the loopholes that there wasn't licensure in some of the counties. Like, think about that for a second. They literally had to go onto the data bank, search it, figure out, oh, not the right license. They don't want to pay you guys. They don't want to pay you. So how do you bring the fight when you're not even compliant? You can't bring the fight. You're in a losing battle from the rip. So in that scenario, I was trying to argue, well, look, they were licensed here, but they weren't licensed here. They didn't care. They said, well, these counties that they weren't licensed in, they're not getting paid for that. And it's a losing battle. And it's unfortunate, and it's horrible, because you may have done the service, you may have done it right, you may have done it, you're a provider, you went into healthcare to serve people and to be caring for people. And now to be undercut like that is devastating. But that is how a simple little mistake and not checking to make sure that you've met that requirement, it's devastating, honestly.
I usually tell people, and it's difficult to say this without sounding very self-serving, you can try and figure this out yourself and do the best you can, especially if you have an infrastructure where you have a staff and you have C-level folks. But if you haven't done it, the likelihood is you're going to screw something up, and at the very least, you're going to delay the process, and that's going to be costly. At the very worst, you're going to screw it up, and you're going to create a bad impression at the government level, so that their inclination is to be very suspicious of any further interaction with them. So it's something that I feel very strongly about when we talk with clients about using us for those things, and it's something that sometimes, frankly, clients need to learn for themselves the hard way. I wanted to circle back to one thing just to clarify something, because I raised this issue in the context of med spas, whether a supervising physician has to be board certified or board eligible in plastic surgery or in dermatology. It comes up all the time, and I wanted to clarify for folks that are watching that issue arises when your business is primarily engaged in facial cosmetic surgery, facial cosmetic procedures. If your business isn't primarily involved in facial cosmetic procedures, then the issue of board certified, board eligible dermatology or plastic surgeon is not relevant at all. Have I captured that?
Yes,
Right.
that
Okay,
is correct.
because we get it so much,
It's a very common misconception.
and it's very easy to confuse it. Yeah, I mean, we'll get folks in the IV hydration space that are asking the question, does a supervising physician of a mid-level have to be board certified, board eligible in dermatology or plastic? And we're like, no, because IV hydration doesn't do facial cosmetic at all. So
Right, absolutely.
that's a gimme. Cool. What else do you want to bat around? Anything else that you want to cover?
You want to talk about like the intricacies of an initial versus a chow, and how that's, because I think clients call us and they get a little overwhelmed when we have to explain that a chow is as vigorous as an initial.
Yeah.
So,
Can you explain the issue of a chow versus initial licensure and what's involved in that? Because a lot of folks that have an ACA license figure that doing a change of ownership, a chow, is just a simple file of paperwork, should be done in 24 hours.
that is a very common misconception, but that's not the case. Typically, we call it a chow. It's a change of ownership notification to ACA, and it essentially is basically an initial application to ACA all over again.
And it triggers at 51%
Yes.
or more.
Yes. So if there is a 51% or more change of ownership with any kind of ACA license, you have to submit a change of ownership form. Again, it is just as rigorous as the initial application. There's a lot that goes into it.
Is it as also as time consuming as the initial application?
Yes, it is, and a lot of times providers think, oh, well, I should just have to let them know, and it's not simply letting ACA know. It's kind of reaffirming all of the, especially for the home health agency licenses, if, what employees are staying, what employees are going, what new ones are coming in, and that process alone can be very time consuming.
Thanks, that's helpful because it is confusing because of this idea of, oh, change of ownership, that sounds like a one-page document that you have to file, and it's not, yeah. So thanks for clarifying. Cool.
Yeah, and like these kind of items, clients always ask us, well, what's this going to cost? And we pretty much do this on a daily, so we can do it hourly as we've explained to clients, or we can just flat fee it. And why can't we flat fee something like that? Because we understand what it takes. We've done it so many times that we know really the amount of hours. So it also creates a certainty for the client to understand. If you come to us, we know it so well that we can actually bet that we know we can do it for a certain price. Where I know that other firms, I've heard of what they've charged for initials and change of ownerships, and I'm beside myself on the cost. And to me, that's just like, maybe you're not with the right firm. Maybe you should question a little bit more of what goes into it. We're open books. We're glad to walk you through the step-by-step, play-by-play. I'll even give you the footnotes because that's how clear we are on this issue.
And I think that it's kind of a gating issue and an ethical issue for most lawyers is like know what you know and know what you don't know and be very transparent about it. And what clients don't want to do and shouldn't do is pay lawyers to learn. Right. Yeah. When I go to an orthopedic surgeon and it's time for me to get a knee replacement, I go to the knee replacement guy because I really don't want somebody figuring it out. And I'm going to find out which one is really known for knee replacements, does them a lot. We don't do everything. We only do what we do. And Charlie Munger once said something that's hanging in our conference room, that knowing what you don't know is more useful than brilliance. And we are strict adherents to that.
Yeah.
So.
Yeah, we recently had a client who came to us who another law firm had essentially strung up a bill, given them basically bad advice in the end, and it to us, when we see that and we understand that maybe the lawyer didn't mean it, maybe it wasn't on purpose, but because you don't know an area, you may mislead and you may hurt somebody, and then we're fixing it, and it's at the beholden of the client, and that's not fair. And we, for us, it's like it's shocking when we see that.
Yeah, and it's unnecessary too because we have plenty of lawyers that we work with. We're not general counsel. It's their corporate lawyer or their general counsel, and we work with them all the time to augment what they do and to help them be more successful by handling this really super specialized area of law and making sure that their client is safe. So it's what we do.
Absolutely.
Yeah. Thanks so much for watching us. This is Jeff Cohen, Rachel Broughton, Carlos Arce with the Florida Healthcare Law Firm. Had a great time talking with you today. We look forward to the next time.